And we are live. Fantastic. Okay, so hello everybody who is joining us on the webinar, and hello to everyone who's watching on Facebook. Thank you so much for coming. Today we are doing one of the sessions, one of our final sessions at the EU Citizens Politics Festival. Thank you for everyone who has joined us this week. It's been fantastic. We've had so many incredible speakers, incredible discussions, and today is a lot more of a practical discussion that is so important to everyone. It's all the questions we've been asked throughout this entire week, so I'm finally glad to be able to say that we have people who are going to be able to answer those questions. You know, we've been directing a lot of people, just come to the session on Sunday and we'll talk to you then. So today is the session. Thank you everyone for coming along, for watching along on Facebook. I will be introducing Andreas, who will take over as host today. If you have any questions, feel free to put them in on the chat if you're watching on the webinar. And if you are on Facebook, feel free to put them in the comments and we will bring them in and we will ask them live. So without further ado, I will hand it over to Andreas, who will introduce our fantastic speakers today.
Thank you, Antonia, and thank you for joining us on this amazing sunny day in England, if you are in England, but you may be watching from other parts of Europe or beyond. As Antonia said, we have two fantastic lawyers who will be speaking about essentially EU students' rights and the EU settlement scheme today. Nilmini Roans is an independent immigration lawyer, and we have Chris Ban, who is an immigration lawyer at Seraphus Solicitors. Thank you so much for joining us on a Sunday and in advance for answering questions that students will ask. We asked the lawyers to provide approximately 20-minute presentations each, and after these presentations, they will take questions. As Antonia said, you can put your questions in the Q&A on Zoom, or you can ask your questions in the comment box on the 3 Millions Facebook page. We will try to answer as many questions as possible. Probably we will not be able to answer all of them, but we will aim to answer many. We will start with Chris Ban, who will speak about the EU settlement scheme, at what EU students in the UK or in Europe need to know about the settled status process, how they can apply, and what they have to be aware of. And after that, Nilmini, she will speak about, she will cover issues more related to universities, student fees and student loans, and that kind of questions. We will try to wrap up this webinar in 90 minutes, and I will just hand the floor to Chris Ban.
Thanks very much, Andreas, and thanks to everyone for joining us this afternoon for the session here. So I'm just going to attempt to share a screen with everyone with a presentation. Although I might, do I have the right to do so? Just bear with me a second. I think I do. But yeah, okay, great. So I'm just going to talk through just the settlement scheme aspect of this. I know we were going to focus on students in particular, obviously, as part of the session, but to do so, we need to sort of understand the underlying basis of the settlement scheme, what it's there to do, what people need to do, why it's beneficial, hopefully, for many EU students to apply to the scheme, and then we can move into a discussion about the sort of parts of the being a student that are obviously different from other people's in terms of fees and stuff, and sort of to do with like home fees and loans and so on. So I'm sure lots of people are very familiar with the scheme, and I do appreciate that. And there has been so many grants under the scheme that it's impossible to assume that people haven't already applied. But we do know that there are still some people to apply, and it may be relevant to people who've joined today. But even if you have status under the scheme, then it's useful to understand it a bit more and what rights it also provides with you, because it's not just about immigration status, as we'll discuss. I will have to fly through this because 20 minutes isn't a long time to talk about the scheme. But essentially, why do we have the scheme? We have the scheme because of Brexit, because of the end of free movement law. And that free movement situation between the UK and the EU ended on the 31st of December. And therefore, what you have is a situation where you have those citizens who have rights under the settlement scheme and under the withdrawal agreement, and then you have sort of new EU citizen arrivals who would be coming to the UK post the end of the transition period and from the 1st of January, who have a different immigration system that applies to them and a much more strict immigration system that applies to them. Just to be clear, I'm going to talk about, I tend to say EU students. What I mean by that is EU, EEA, which is Norway, Iceland and Liechtenstein, and Swiss citizens as well. So when I talk about European or EU students, I'm talking about everyone, because effectively there is a withdrawal agreement between the UK and the EU. There are also very, very similar agreements between the EEA countries and a similar agreement with Switzerland. So essentially everyone is in the same boat, and the settlement scheme recognises that, and so all of those nationalities will be applying to the scheme in most cases. What we have under the withdrawal agreement with the EU is a set of obligations that the UK has towards EU citizens. It's under part 2 of the agreement, and it is wider than just immigration status. I would say probably the most important aspect of it is the immigration status side, because people need to be able to live in the UK lawfully, and the rights under the withdrawal agreement guarantee that for citizens. But it is wider than that. There are other aspects of it to do with social security coordination, to do with essentially like equal treatment, to do with recognition of qualifications and things like that. So it's not, we don't just talk about the right of residence under the withdrawal agreement, but the EU settlement scheme is the Home Office process to grant the residency rights under the withdrawal agreement. And so, as we say, the key is it applies to citizens living in the UK by 31st of December. There are some situations where family members can join the principal EU sponsor after the 31st of December. There are rights to family reunion under the withdrawal agreement, but by and large, we are referring to people who have lived in the UK by 31st of December at the last, as the cut-off point. And that's essentially what the slide is saying. It's saying if we're talking about people who are resident before or by 31st of December, they are covered by the withdrawal agreement, the settlement scheme. Those who have not moved to the UK, and that would include, of course, future students, are not covered by the scheme unless they would be a family member of someone who is covered by the scheme. But by and large, that might not be the case, and so they would be subject to the new, sometimes referred to as the points-based immigration system, which, as I say, is a lot more stringent than free movement law that it's effectively replaced. So just to kind of whiz through the settlement scheme, we have 2 possible statuses that are issued under the scheme: settled status and pre-settled status. And the difference between them essentially is settled status is a permanent status. It lasts indefinitely, subject to a couple of minor conditions, and it is awarded to those who have lived in the UK for a continuous period of 5 years at the point when they apply. If someone applies to the settlement scheme before they have lived in the UK for 5 years, then they're going to be granted pre-settled status, and that's a grant of status for 5 years. And the idea would be that within those 5 years that you're granted pre-settled status, you will cross over the point when you've lived in the UK continuously for 5 years, and at that point you're eligible to apply for settled status. And you can do it as soon as you've got the 5 years of qualifying residence, or you can do it towards the end of your pre-settled status grant. But you do have to make a second application, and it does have to be before the pre-settled status expires. The deadline for everyone to make their first application to the scheme, so either you'll know whether you've lived in the UK for 5 years or not, so you know that you're either applying for settled status or pre-settled status, and that first application has to be made by 30th of June. So we are very close to the deadline to apply to the scheme. There is the ability to apply late to the scheme if you have a good reason to do so, but it's really a terrible idea to do so. And hopefully very few people will fall into that sort of late application situation, because unfortunately, what happens is whilst you're trying to resolve your application, you lose the rights that you have to essentially to live as a lawful resident in the UK. So it's a very difficult situation. We don't want people to apply late to the scheme if we can avoid it, and that's part of the reason why so much of the work is to publicise people applying to the scheme. And within that context, we have to identify who is required to apply to the scheme, because it's not quite as straightforward as it sounds. By and large, well, we say European citizens, as in EU, EEA and Swiss citizens, have to apply to the scheme. Family members of those citizens usually have to apply to the scheme as well. And that does include people who've already obtained documents under European free movement law. So in many cases, we're talking about permanent residence documents. Non-EU family quite often have a residence card that's issued by the Home Office under European law. Again, that is not going to be valid beyond the 31st of June because it's issued under European law, not under UK law. And so those people do have to apply. There is an exemption for people who already hold a status called indefinite leave to remain or indefinite leave to enter. And that tends to be people who've lived in the UK for a lot longer, for many decades in cases, but they don't need to apply, but they still can if they want. If someone is a dual EU British citizen, they can't apply to the scheme because they don't need an immigration status. They have British citizenship, which gives them the right to live in the UK. So they don't need to apply, or they cannot apply. And Irish citizens always have the choice whether to apply to the scheme or not, because they have a different set of rights to live in the UK, which is unconnected to the EU. And the final sort of point that we always try to emphasize is that children do need to apply to the scheme individually, and that includes children who are born in the UK unless they're born British, but it's not always straightforward to know whether a child who's born in the UK has been born British or not. And so parents always need to look into that situation, and generally they're going to need to make an application for that child. When you make an application, the idea of the process is it's supposed to be straightforward. In a lot of cases, it may well be straightforward for people. We shouldn't assume that it will be straightforward to people either to apply or to get the sort of documents together that they need to evidence their application. But obviously, a lot of people have applied to the scheme, over 5 million, and coming up to 5 million grant or sort of decisions made under the scheme. So lots of people have coped with applying to the scheme, but I also think that we need to recognise not everyone is able to do so by themselves, and does need help, and not everyone has a straightforward situation. But when you do apply to the scheme, you're essentially, as a European citizen, you're being asked to do three things. You're being asked to prove your identity and nationality. You're being asked to prove that you've lived in the UK before 31st of December 2020, and depending on which status you're applying for, settled or pre-settled, you're asked to prove a period of residence, which will depend. Obviously, if it's settled status, you're being asked to show 5 years of status. And then you are asked to make a criminal offences declaration relating to any convictions that you may have. And I've put a number 4 there. If you are a non-European family member, then you do need to evidence your relationship or a former relationship if it's broken down to a European citizen as part of the eligibility criteria. By and large, you do all of this online. There are some applications that have to be made on paper forms, and if someone can't obtain a valid passport or national ID card in time for the 30th of June, then they have to apply on a paper form, which involves contacting the Home Office and asking them to issue one, which is something that we see more and more at the moment, given how close we are to the 30th of June. I'm just going to focus on continuous qualifying residence for a little bit, because it's something which has definitely come up an awful lot with the work that we do, particularly in the student context, and particularly because of the impact of COVID. And so essentially what we have, and this is really, when we talked about continuous qualifying residence, we're talking about people who are applying for pre-settled status. And we know if you're applying for settled status and you've lived in the UK continuously for 5 years, then you've got your qualifying period sorted out. and then you're granted settled status and you can be away for up to 5 years. And so you have, it's not, well, if you're getting settled status, your need to continue living in the UK by these strict conditions, it disappears at that point because you can be away for up to 5 years. But if you're within your 5 years of qualifying residence, if you've been granted pre-settled status or that's what you're applying for, you need to bear in mind a few things. And that is essentially, your continuous qualifying residence begins when you move to the UK, or whatever date that was is essentially the start of your qualifying residence. And then what you have to do is you have to maintain enough residence in the UK to be considered to be resident here, and that's fairly straightforward. It's as long as you're here over 6 months in a 12-month period, then you're considered to be resident here. But if you exceed 6 months of absences, and that means either in a single stretch, or if you added up multiple absences together and in a 12-month period and they exceeded 6 months, and you would be considered to break your continuous residence, which is a problem, because if you break your continuous residence, then you have to start the 5 years all over again. But you can only do that if you start the new 5-year period again before 31st of December. No one can start a new period of qualifying residence now if they've broken their continuous residence, and that is something which has been a bit of an issue, particularly, like I say, within the context of COVID. When you are within your 5 years of qualifying residence to be building up to your settled status 5 years, you are allowed one period where you can have a longer absence of up to 12 months, as long as it's a single absence and it's for an important reason. And the bullet points there set out the indicated important reasons that might apply to people. Don't assume that that's not an exhaustive list. It's just an indication of what situations might arise. You can see studying in the middle there. So in the past, what that would have been about is someone starts at a UK university, and part of their course is you go away and do sort of up to a year at an overseas university, you come back to the UK, carry on with your studies. And if you did that, even though you've got that longer absence, you wouldn't have broken your continuous qualifying residence because your absence was for an important reason. So that's how it was intended to work. But then you have COVID, and what's happened a lot for students because of COVID is essentially, face-to-face tuition has shut down for a long period, and many students have effectively moved their studying remotely and in many cases away from the UK. So if that's what's happened to you or to any student, then what it means is that you will have to rely on a guidance document that's been issued by the Home Office, which talks about students and why they might have been away for a period of or longer absence. And it basically says if you're studying remotely, you started your studies in the UK before 31st of December, but your university moved you online, or if you're younger than that, if your school sort of effectively did that, then you would be, you're considered to have an acceptable reason to be away for up to 12 months. So for that important, it says it's an important reason. What it doesn't do, what the Home Office hasn't done is extend that 12-month period. And that's really, really crucial, because obviously the pandemic began in March 2020, effectively, in this country. And so we've gone over 12 months now. We're into 13 months of pandemic. And so if someone left in March and is still away in April 2021, then they will be looked at as someone who's broken their continuous qualifying residence because they've been away for too long. Even if they've even if they've been studying remotely all that time, it's got to 13 months and the rules don't allow you to exceed 12 months. So it's something that we're unfortunately encountering that has happened to people, and it's difficult because even if you've got pre-settled status in place, in principle, it means that you're going to struggle to convert that to settled status or reapply when you make a new application for settled status in the future. You won't be able to have the qualifying residence that you need to get settled status. And if that happens, you end up without any right of residence in the UK. It's a very difficult situation to be in. Just to kind of, again, moving quickly through the process. So on the assumption that you have been granted status, or when you're granted status, if you're still yet to apply, you'll be given, as I say, settled status or pre-settled status. If you're given pre-settled status and you think you should have settled status, you can challenge that decision. It depends on why the Home Office thinks that you haven't shown them that you should be qualifying for settled status, but you are allowed to challenge that decision. And as I said, there's a big difference between having the two statuses, because settled status means that you have the permanent residence, and really the key here is that you then are allowed to be away from the UK for up to 5 years. It says four if you're a Swiss citizen. I don't know why there was a different time frame for Swiss citizens, agreed. If you're in the pre-settled status, if you're granted pre-settled status, then you have to go back to what I was talking about with the continuous qualifying period, because you have to be here for more than 6 months in any 12-month period. Because that's the rule until you cross the 5-year barrier and you can get settled status. That's what you're obliged to do. So obviously, like I said, they're very, very different conditions depending on which status you end up with. Down the bottom there, it just says, in line with the Home Office policy on immigration status, if someone commits an offence, criminal offence, after they've been granted status, the Home Office can, in cases, revoke the status and try to remove the person from the UK, and they probably will do, particularly if it's an imprisonable offence. I'm sure everyone will sort of be familiar with the discussion about the type of status that's issued, which is a digital status. It is not a residence card, it's not physical. It is a status that you log into a gov.uk website to review, and you will see your own picture, and it will say whether you have pre-settled or settled status. And when immigration checks kick in, really this will be from the 1st of July onwards, when people will be required to pass immigration checks from employers, from universities, from the NHS, and so on. It'll be the digital status that proves that you have the rights under the settlement scheme, and to prove to that organisation, be it government department or a private organisation like an employer, that you have the right to be in the UK and to undertake whatever activity it is. So people need to get familiar with their digital status and understand how you log into it, and try to keep it updated, particularly if you get a new passport. It's useful to have it updated for the purpose of entering the UK. That's really what that slide covers. I think I'm going to sort of pull up here because I've probably hit my 20 minutes, but just to say, the purpose of the withdrawal agreement and the status under the withdrawal agreement is to give those who benefit from it equal treatment. And what that means is the rights that, when we're talking in the context of student fees and so on, is the rights that citizens, EU citizens, had before Brexit to home fees and to maintenance loans, etc., is preserved. So it means, it's not just it's not always as straightforward as you have status in the scheme, therefore you have home fees, because there are residency conditions that are applied to home fees. But the point is that the situation essentially remains consistent, and it's because it's based on the right of equal treatment, which is in the withdrawal agreement. So I think we're going to probably come to that a bit more in the next discussion, but I will stop there. Hopefully that was helpful for people. It was quite a lot to squeeze in to 20 minutes. Okay, thanks.
Thank you, Chris. That's fantastic. Congratulations on doing it in 20 minutes. It's quite an achievement. It's such a huge topic. So yeah, well done. We have received quite a few questions already while you were speaking, and we will ask these after the next presentation. So Nilmini, the floor is yours now. Thank you.
Thank you very much. Thank you so much for the invitation, Young Europeans Network. I'm going to do my very best to share screen. Give me 1 second. Oops. No. I think that's doing it very well. Bear with me. Okay, I think that's slightly better. Can you see the screen? Can you see the screen?
I can, yes.
Yes, you can.
All right, excellent. Thank you. Right. I hope you can still see the screen, and forgive me for that little technical hiccup. All right. So I'm Nominee Rowlands, and I'm an immigration lawyer. Chris then covered the position of those who qualify under the EU settlement scheme. Now, I'm going to divide my section into three parts. First of all, in relation to those people who don't qualify under the withdrawal agreement, and so people who are coming in to the UK from the 1st of January 2021, and also talk a little bit about the sponsorship concept for students, so that you start to get your heads around those. So essentially the first two sections with regard to people who don't qualify for the EU settlement scheme. And then the third part is really about the student finance, which I think is what is of concern for most people. So the three parts: the new regime under UK law, and secondly, the concept of an educational institution as a sponsor of a student, and thirdly, the student finance for EU students. There's a lot to cram in to these 20 minutes, so I've actually asked if I can just overrun a little bit. I hope you'll forgive me. So the new regime under UK law: if you're not in the UK by the 31st of December 2020, then you're subject to the UK's domestic immigration rules, and they are much tighter, much more difficult to meet. So I've put here that it's a new part for students, because it really is means getting used to a new way of thinking. And that's quite crucial, because I was talking to Chris the other day, and he was saying that there are still people who are turning up at immigration and saying, I want to come and study here, I want to come and work here, without anything other than their passports. So it's and then being turned back. So it's really important to understand and get a shift of approach and looking at this new path under the immigration rules. So what it means is that you now have to qualify for entry to the UK. You need to apply for entry clearance from abroad, for leave to enter, for permission to enter the UK. And once you're actually in the UK, then you have to apply for an extension of your permission to stay. And then eventually you might want to apply for indefinite leave to remain. And then perhaps you might want to actually become a British citizen as well. That's a matter of choice. But the student route has its limitations in terms of qualifying for indefinite leave to remain, as you might discover. But the fact that there is no more free movement means that you do have to wait around for decisions like the rest of the world now. So you can't, unfortunately, just walk through immigration as you did once before. You have to make these applications for visas from abroad, and unless you're coming here as a visitor, of course. So this is quite a shift in thinking. And it also means that you have to fit into an immigration category. There are different categories under the immigration rules. So you have to fit into a category and apply for permission to enter. That also means that you may be subject to the restrictions on switching between the categories as well, which is a concept that's going to be novel for EU nationals. And the one that's most difficult, I think, for EU nationals to get their heads around is the fact that you have hefty UKVI fees to pay for visas. And in addition, you've got an immigration health surcharge. I understand that one of the questions that was asked was about insurance for students. Well, when you apply for a student visa, you also have to pay something called an immigration health surcharge. And that's quite expensive. It's £624 per annum. So for each year of your course that you're going to be here for. That actually, in essence, covers your access to the NHS. You are also going to be subject to English language requirements. You have to meet a certain level of English language, which you have to prove, and also maintenance requirements and suitability in terms of your any antecedents, that you don't have any criminal convictions and that sort of thing. You also have to give your biometrics. So these are all novel concepts for EU nationals. And in terms of fees, as I said, when you're applying for a visa from outside a student visa, it's considerably higher than any application you might have had to pay before the 3 million intervened for a EU permit. But this is 348 pounds for a student visa from outside, and then for an extension, 475 pounds. And then the IHS has said 624. And eventually, if you manage to remain lawfully in the UK for at least 10 years, you might qualify for indefinite leave to remain. And then there's this hefty £2,389 that you have to pay. So you can see just that shift in thinking. The fact that you have to pay these huge fees is something that, unfortunately, that you're going to have to get used to. And also it means that you might be subject to conditions of your stay. There are things that you can and can't do. There are conditions that are going to be attached to your permission to stay in the country. So if you're here as a student, you can study, and you may be able to undertake certain limited number of hours of work, depending on whether it's term time, vacation time, and depending on the level of the course that you're doing. But you can't, for example, claim public funds, and you can't set up in self-employment, for example. So there are things that you can and can't do that will be applicable. And also, you might want to think about the different categories relating to student visas. You might have a student category, which is for somebody above the age of 16 or more, coming to study at a further education or higher education institution. Or you might have a child student who could be up to the age of 16 and perhaps right up to the age of 18. You could potentially qualify as a child student as well. And then you have short-term students coming for less than a year to study English. And then you might have a parent of a child who's a very young child being accompanied by a parent. So these are study-related visas that you might qualify for. And then you've got work-related visas that might be of interest to students. There's a new graduate visa that's coming in from the summer. And then you might have a skilled worker, global talent, startup, innovator. These are supposed to be replacements for the entrepreneur category. But basically what I'm trying to say is that there are things that you might switch into having come in as a student. So that's the kind of an overview of permission to enter and extensions of permission to stay. The next thing that I wanted to cover was this curious concept of sponsorship that you will need to get used to if you're coming in from the 1st of January as a newcomer to the UK, because you're going to have to be sponsored by an education institution and under the domestic immigration rules. There are different types of education institutions. There are the universities, the higher education providers, the private providers, for example, independent schools, international colleges, English language colleges. Then there are the theological colleges, for example. And these may all become sponsors of students. It's also the overseas higher education institutions where you do you'll start your course overseas, but you might come over here for a short-term study abroad program. Then going back to this concept of sponsorship, the college, I'll call it college for shorthand, it applies to universities and all institutions, education institutions. The college will have to issue you what's called a CAS, a Certificate of Acceptance for Studies. And by that, the college becomes responsible for your compliance, your migration compliance. And so this means that the college is entitled to monitor the students' progress, academic progress, as well as the students' attendance. And if you fail in any of that, in your progress or your attendance, the college, the sponsor, is entitled to report against you to the Home Office. So this is why I think it's important for EU students coming in under the domestic rules will need to get used to this concept of sponsorship, because it's a very different regime to the one that you might have been used to in the past. Just to drive home the message, I wanted to actually read this bit out because it is really important, because the sponsor obligations of an education institution means that they take responsibility for all its sponsored students while it's sponsoring them, including by doing all it can to ensure that prospective students are genuine students who can comply with the immigration rules, and that students enroll, comply with their conditions of leave, and see their course through to completion. So there's a lot of monitoring by the college, and you will need to get used to this. And so when the college assigns this certificate of acceptance for studies, a CAS, they will look at the ability and the intention of that individual student to study. They'll look at the English language requirements, and they'll look at the academic progression before they actually assign a CAS. And then they'll also make sure that you're meeting the maximum period that you can actually stay in the UK as a student, at that level. So these are duties and obligations of sponsorship on the college, which include reporting and record keeping duties. And so therefore they'll be passing on some of these duties by monitoring you quite closely. There's something called a basic compliance assessment that universities or colleges who are sponsors have to do on an annual basis. And as a part of that, they will actually need to meet certain visa refusal rates, which must be less than 10% of the previous year, and make sure that more than 90% of students have actually enrolled, having had a CAS assigned to them, and that more than 85% of students actually complete the course. And because of this, the college actually giving you a CAS will be very, very careful to make sure that they can meet their basic compliance assessments, and therefore the monitoring of the student, the academic progression, ability and intention to study, all of that, the attendance monitoring will be quite rigorous. So that's to give you a flavor of the record keeping duties and the reporting duties of the sponsors, which mean this close vetting and monitoring. And the fact that you need to keep them updated on any changes of your contact details and that sort of thing. Lots of obligations on the sponsor, which then they pass on to the student in turn. So that's that second part in terms of the concept of sponsorship. I want to now move on to this topic of student finance for EU students. Right now and going forward, I think Chris already mentioned that those who are covered by the withdrawal agreement, those who qualify under the EU settlement scheme, by and large, things will carry on as before, subject to residence requirements. But there are two key concepts when it comes to student support. And one is the concept of home student fees, which means that you pay a lot less than if you're an overseas student fee payer. And then the second is whether you're actually eligible for student support funding. This is the most important document that you need to become familiar with. And I've actually quoted a chunk from it here on the screen, which I'd like to read out, if I may. And this is the new eligibility rules for home fees, home fee status and student finance for the 2021-2022 academic year. So in order to get the home student fees and student support, they begin in this tone, if you like. They say, now that we have left the EU and will no longer have the legal obligations of membership, it is right that EU and other EEA and Swiss nationals are in future treated the same as those from other countries. They say it's right, it's right. That's the tone in which this document begins. Therefore, EU, other EEA and Swiss nationals and their family members not covered by the withdrawal agreements or the common travel area arrangement with Ireland will not be eligible for home fee status and student financial support from Student Finance England, for example, if starting the courses on or after the 1st of August 2021. So 1st of August, when does your course start? If it's starting after the 1st of August, this bites. So this is a document that's well worth anyone who's intended to study after this date actually taking, downloading and studying quite carefully. So they're saying that, again, using Chris's shorthand, EU nationals, which encompasses all these different nationals, will continue to have access to home student fees, broadly on the same basis if you're covered by the withdrawal agreement. And those are the people that Chris mentioned earlier, those living in the UK by the 31st of December, and who continue to live in the UK after the 31st of December. And then those people will have applied in general for the pre-settled or settled status under the EU settlement scheme before the 30th of June 2021. As Chris said, it is a terrible idea to not do it. Please, if you qualify under the withdrawal agreement, please apply before the deadline. Don't wait for any exceptions. Apply now. So then in terms of student support, what does it comprise of? Basically, it can cover a loan for your tuition fees, the course fees, and then a loan for your living costs, your maintenance, your for your rent, your food and that sort of thing. And then certain supplementary grants might be available for certain categories. For example, if you're a disabled student, and also there could be a non-repayable maintenance grant as well in certain circumstances. And you may then be entitled to a bursary from the actual university itself. So these are the things that are available by way of student support. The rules relating to student support are extremely, and I underline the word extremely, complex. And some of the rules are not even clear yet. And they tend to depend by and large on your nationality, your ordinary residence in the UK and Islands or in the EEA, and where you'll be studying, which bit of the UK, which country will you be studying in, and when does your course start, and what level is your studies going to be at, and your personal circumstances. There are lots of complicated factors here. So this is why it's very difficult to give anything other than very generic answers to anybody who might have a question about, am I eligible? Because it's a whole load of factors that go into that decision. What I wanted to do was to actually draw your attention to the various resources that are available to students so that you can yourself find a path, find your way around these available resources and try and find the answer for yourself. By far the most important one is the gov.uk website itself relating to the particular nation that you're going to be studying in. So for example, in Scotland, you've got the Student Finance Apply and UK CESA, UCAS, university's own websites, the complete university guide, which is fantastic, and savethestudent.org. Now, just so that you're aware, there are tons of resources available on the internet, but these are among the more respectable ones and the essential ones right at the top. So in that order of relevance and interest. Just to drive home the importance of UCAS, Universities and College Admission Service, here's their website address. And if you can log into that, right at the top right, you've got here Student Finance in England from that UCAS website. If you go into that, you'll discover loads and loads of resources there. And also, once you're here as an international student, as opposed to an EU student, and even as an EU student, there's lots of resources on the UK CESA, UK Council for International Student Affairs. Tons of information in there. The other one that I mentioned earlier on, the Complete University Guide, they've got a very colourful set of resources covering lots and lots of different topics. So again, I've given the link here, so you can actually go and find out more and more about the different topics. It includes things like the Turing scheme, which replaced the Erasmus sort of replaced it. And then other types of issues relating to scholarships and bursaries, postgraduate funding, and about how you repay your student loan. Lots and lots of interesting and relevant information on the Complete University Guide. But also this is the gov.uk guidance for EU students. Again, please go into this and study this carefully, because you will find a lot of the answers online in the gov.uk and these other resources I mentioned. So student support in England, you've got these eligibility rules that I mentioned at this link here. It was published in December 2020, and it relates to the academic year 2021 to 2022. And this is the key document that you really need to be studying. There's also another document which is of interest, which covers the grace period, which is the period up to the 30th of June. So again, this is going to be of interest for you. The EU settlement scheme grace period. Do study that too. If you are going to be doing a course in Scotland, then go to this and discover the Student Finance Scotland, which is the Student Agency Award Scotland. Again, I've given you the links. It's got a Brexit guide, and you've also got Student Finance Wales, and you've got Student Finance Northern Ireland. So in each of the different countries from where you're living, you need to look at that. Then you've got the EU settled status, which Chris mentioned earlier on. You will generally be eligible for home fee status, tuition fee and maintenance support if you've been ordinarily resident in the UK and Ireland for at least 3 years. The residence requirement is for 3 years of ordinary residence. Irish nationals are automatically considered settled. They have special consideration under the Common Travel Area. So you need to look at this. If you've got settled status, by and large, you will have had 3 years ordinary residence. So in general, you would qualify. If you've got pre-settled status, the student loan company will accept pre-settled status together with ID documents as evidence for the purpose of awarding student support. But likely that when they're awarding home fee status, they'll look at your residence again. But you need to be aware that if that residence was wholly or mainly for the purpose of education, then that might affect your entitlement. So that's something that needs further investigation. So some of the guidance isn't terribly clear, but be aware that if you've got pre-settled status, then what was the purpose of your residence until now for those 3 years is going to become relevant. It's all to do with fee status. So it's your fee status that governs whether or not you pay home or overseas fees. It makes a big difference because home fees are about half of what overseas fees are. So it's quite important to check whether you're eligible. And that in general, your fee status depends by and large on your nationality, where you live, and how long you've lived there. The government sets out the regulations for fee status, but the universities make their own assessment based on those regulations. So if you've applied to more than one university, it may be that different universities make different decisions about your fee status. As I said, it's laid out in regulations, and you've got the regulations, the Education Student Fees Awards and Support Regulations 2021, The amendments came into force on the 1st of March, but the position after the 1st of August 2021 is not very, very clear, and a lot of people are still trying to decipher some of it. And each different country has its own criteria, depending on the country that you'll be studying in. So depending on also the course, the institution that you'll be studying at, what level, of course. Just want to highlight the fact how this is so complicated and that it's not clear yet, because UKCISA website itself says we're busy analysing the regulations, those regulations that I mentioned just now, but they're long and complex and full of references out to EU law and the law relating to Brexit. So that will take time. We appreciate your patience while we do that. We'll not be able to publish information about the eligibility criteria for each of the categories of student who are entitled to pay fees at the home rate until we complete that analysis. This is just to give you an idea of just how complex these rules are. So the UKC says asking people to be a bit patient about that with regard to the post 1st of August 21 position. We talked about the concept of 3 years ordinary residence. Now, the term ordinary residence isn't defined in an act of parliament in statute. It actually comes from case law. And basically what it says is that ordinary residence is established if there's a regular habitual mode of life in a particular place for the time being, whether short or long duration, the continuity of which has persisted apart from temporary or occasional absences. Residence must be both voluntary and adopted for a settled purpose. So you can see that the concept of ordinary residence that enables you to qualify for home student fees after 3 years, it's quite a complicated assessment. So this is why it's not so straightforward. You'll see that the Home Office ordinary residence guidance talks about lawful residence in the following categories could constitute ordinary residence. For example, if you're entering to the UK for settlement, for employment, business, self-employment, study, retired persons, etc. But then it's not terribly clear, because the eligibility criteria guidance that we just talked about for 2021-2022, that has a slightly different definition. So it's not quite clear just being here for the purpose of studying, if you've got pre-settled status, will mean that you qualify. So this is why there could potentially be a little bit of a tension between the two. So just look at the language here under pre-settled status in this guidance. It says, in practice, the student loan company will accept pre-settled status together with ID documentation, etc. We anticipate that providers will take the same approach when awarding home fee status, where the student has 3 years residence in the UK, Gibraltar, EEA, Switzerland, or the British EU overseas territories. EU nationals and their family members will generally be awarded tuition fee support by the student loan company. Unless that residence wholly or mainly for the purpose of education. So just be aware that if it's pre-settled status, it's not so straightforward. Then EU workers and their families. The student loan company will award tuition fee and maintenance support to EA and Swiss workers and their family members, where the students got pre-settled status and 3 years residence in the UK. This also applies to frontier workers. But as I said, the rules are quite intricate, so you need to go in and check things out. But in essence, EA workers could also be covered for studying and for student support. Student finance. So what does this cover? Tuition fees loan, it covers the course fees, and it's paid directly to the university or the college. It doesn't come into your hands, it goes direct to the college. The maintenance loan for the living costs, on the other hand, comes into your bank account, but both as a lump sum has to be paid back. It's only a loan, and it depends on your future earnings. So if you're a really high earner, you might start to pay back. If you're a very low earner below a certain threshold, it may actually be that you never end up paying it back. But there are complicated rules relating to how you pay back your student loan as well. So these are, again, things that you'll need to investigate at close range afterwards for your individual cases. Just to give you an idea of what a student fee loan would cover for the tuition fee. So full-time students, 9,250 for both these academic years now and for next year. And then part-time students, you've got 6,935, so on and so forth. Then the if you are not eligible for home fees and you have to pay overseas fees, as you can see, it could be double that. There's also a DSA, Disabled Students Allowance, which will cover study-related costs you might have because of a mental health problem, long-term illness, or any other disability. So you need to be aware of what's available. There's quite a lot of support available, and just eke it out somehow from the various websites and the resources that I've pointed you to. And this can be on its own or in addition to any student finance you get. And it really depends on your individual circumstances, your rather than your household, not based on your household income. And you might get specialist equipment, non-medical helpers, extra travel to attend your calls, and a lot of support, and you don't have to pay it back. So there's quite a lot of money available for that. And also there could be non-repayable allowances for parents and carers if you've got dependent children or adult dependents. You might be entitled to certain allowances as well. For example, the Parents' Learning Allowance. In Scotland, it's called the Lone Parents Childcare Grant. And you could have a childcare grant, or you could have an adult dependence grant. So there are lots of things available in addition to the usual loans and things. So with regard to maintenance, help with living costs, you may be eligible for help with your living costs if both of the following are true. If you've lived in the UK for more than 3 years before the first day of the first academic year of your course, and you have settled or pre-settled status. So for example, if your course begins on the 20th of September 2021, you must have lived in the UK since 1st of September 2018. And note that the academic years start on the 1st September, 1st January, 1st April, 1st July. So you need to ask your course provider as to which one's relevant to you. There are online applications for student finance. You need to go to this particular link and complete the online form. But for certain things, you submit an application by post. So just be aware that there are some things that you have to apply for by post, but on the whole, it's an online application. And your parents will have to provide their household income details. If it's possible to condense a message from all of that, and it's very dangerous to do so, I realize, because it doesn't cover everybody's position, but in general, if your course is starting on or after the 1st of August, you really need to have settled or pre-settled status to get your student support. Anyway, so that's all I wanted to say, and managed to finish it bang on to. There you go. Thank you. Thank you for listening.
Thank you, Niamini. That was fantastic. Such a comprehensive presentation, and so many resources, links that you have shared. So thank you so much. Thank you very much. We have received a lot of questions also on student finance and fees during your presentation. But let me take the first question for Chris. Chris, this is going to be about the digital status. Quite a few people are asking how they can prove the status as now it's all digital. If you are an EU student in the UK and you have already applied for pre-settled or settled status, and your university is asking to prove that, how can you do that, or how can they do that?
Yeah, okay, thanks. Yeah, I've seen, obviously there was a document sort of compiled in advance of the session as well, and people asking about ID card, and obviously, as I covered in the presentation, there is no physical ID card for European beneficiaries or those granted settlement status, pre-settled status under the EUSS. It's digital status only. When you are granted status, you are given a letter or emailed an electronic letter from the Home Office, and it tells you, gives you a link to, it says that you can log into. It's proven sort of my ID or something, prove my rights. But essentially it's the link to the profile. It's a live link in that electronic letter. But if not, you can just put EUSS profile, view my profile into Google, and you'll find the gov.uk link that you need. And then, as I say, once you go into that, into your digital profile, you'll see your own picture, and you'll see it will tell you the status is granted. The idea within the profile is that you can, for certain organizations or certain actors, generate what's called a share code, and it's like a code. It's a unique code that's generated about you. It's certainly active for employers, where you can give that code to an employer, and they can then check. Essentially, they put that code into a Home Office, another UK gov.uk website, and it will bring up confirmation for them that the status is valid. I have to say, in terms of universities, I don't know if there's a code specifically for universities within the digital profile, because the Home Office has been developing the profile at different speeds for different sort of organizations, employers. One is up and running. DWP is supposed to have one at some point, so it may not be that universities can have the code yet. I'm sorry, I just don't know. It's possible, but if not, essentially someone could, you can demonstrate. I mean, you can show of course your profile to someone who's at a university fees office in that sense. I'll have to check if there is. I'll see when we're answering some other questions if it is included in the way that the share codes are generated. But in essence, it's all digital, and you use that profile to show people at various different actors that you have the status under the scheme.
Thank you, Chris. Nilmini, we have also received a question in the Zoom Q&A from a Polish student on maintenance loans. He wrote that he has been living in the UK since July 2020. In October last year, he applied for a maintenance loan, but despite proving continuous employment, the student finance still did not grant him a maintenance loan. And every month they ask for further evidence, and they haven't given him the loan. So I think the question is, how can he prove that he's eligible for the loan? I think you are muted, Nilmini.
Hi. Okay, so if he's been around since July 2020, he's eligible for pre-settled status. I'm presuming that he's already applied and is able.
He didn't say that in the comment.
Okay. If he hasn't done so already, I think it'd be really advisable to apply for under the EU settlement scheme, and then provide the share code to prove that he's entitled to pre-settled status first of all, and that might resolve some of the issues. It's quite tricky to answer very specific queries relating to an individual's circumstances, but in general, if you're here before if you're living here before the 31st of December, apply under the EU settlement scheme and provide evidence of that to the student loan company, and hopefully that'll help. But if you want to qualify for home student fees, that's different, because you have to have 3 years residence that you need to prove. But if you're a worker, I mean, it'll be worthwhile, I think, this individual looking through some of the resources that I've highlighted and trying to decipher the bits that's relevant to them, and then prove their status, and hopefully that'll resolve things.
Yeah, thank you. I would also say to the people who are watching this online or on Facebook that the lawyers cannot give specific legal advice. They can only provide information in general about the scheme and about the student fees. Moving on to Chris again, if I may, we have received quite a few questions on continuous residence. Chris, you talked about this in your presentation, but there are quite a few questions. I think it's good to highlight some of the key parts of this issue. There is someone who was asking that, where is my question? Yeah, my pre-settled status will expire in July 2024, and I'm afraid that I have broken my continuous residence by being outside of the UK for more than 6 months, but less than 12 months. I will be starting a PhD in the UK in September 21, and it will end on September 2025, which is more than 1 year after my status expired. Will I have to apply for a student visa during the course of my studies?
Yeah, okay. I mean, so the first thing that to pick up on there is that what is the standard rule. So the person saying the standard 6-month rule seems to have been broken, and that's obviously what's causing the concern. So at that point, the first thing I would then assess is to look at the important reason absence, the kind of exception, the one time that you're allowed to have a longer absence than 6 months, which is up to 12 months if it's for an important reason. So that's what this person would want to assess first of all, can they explain why they've exceeded 6 months outside the UK? Is it for an important reason? Is it connected with COVID? Is it been studying? If you've been studying remotely, then that's covered by the COVID guidance. Is it for something else? Is it to do with illness related to COVID or not related to COVID, or another reason? So, because if you can explain that you've been away for longer than 6 months for an important reason, then as long as it doesn't exceed 12 months, then you haven't broken your continuous residence. And therefore, when you come back, your ability to qualify for settled status is sort of on track, if you like, once you've crossed over the 5 years. If you sort of don't feel that you have an important reason for exceeding the 6 months, then it is obviously that's more of a problem, because you on the way that the scheme operates today is that you wouldn't be able to qualify for settled status in the future. And the outcome of those situations, and it will, I'm afraid that it will apply to some people. They won't be able to necessarily be granted settled status in the future. What the Home Office expects at that point is essentially one of two things happens. Either that person applies into an alternative visa route under the sort of immigration policy, as we've heard of it in the student category, if that's what the person will be doing, or their right of residence in the UK will expire and they'll be expected to leave. So the answer that there's two sort of potential situations for this person, but obviously what we would hope is that they're able to explain the absence that's exceeded 6 months is less than 12 months for the important reason, because that keeps you on track to get settled status in the future without having to worry about student visas and so on.
Because it's very related to this question that's coming from TikTok. What is the 12-month period? Because I know that you guys mentioned and someone has asked if it's like January to December or something else.
Yeah, okay. So when we talk about 6 months and 12 months, what do we mean by that? It's a good question, and of course, because I'd love to give you a really straightforward answer, but I'm not going to be able to for a reason I'll explain. It is not, the Home Office does not define it as a sort of calendar 12 months like January to December, nor does the Home Office count it as if you entered in July, from July to the following July is your 12 months, and then you move through 5 of those. That's not how the Home Office interprets it. What they say is that the 12 months is moving all the time. It's moving. So if you, let's say, if you have sort of 3 months outside the UK towards the end of one calendar year, and then you come back, and then in the next calendar year at the beginning, you go away for 4 months, the Home Office says, well, we'll combine that together, and that's 7 months. And your 12 months is always moving. So you always have to assess whether you've got more than 6 months in any 12-month period. That's the way the Home Office interprets it. Now, this is where it gets confusing, because the EU doesn't interpret it in that same way. They say it is actually a fixed point in time. There's a document, I'll try and get the link into to make it available, but what they say is actually we consider your 12 months to begin when you enter the UK, when you start your continuous period. So what you have is a difference of interpretation, and it could be a crucial difference of interpretation for some people. It's not going to affect everyone, but it could affect someone. And essentially, the operation of the withdrawal agreement says that where there is a conflict between the sort of the settlement scheme rules, because that's what the Home Office is basing. They're saying we're implementing the withdrawal agreement through the settlement scheme, and where there is a conflict between the rules as written in the settlement scheme and the withdrawal agreement, the interpretation of the withdrawal agreement has to be preferred. It's the sort of superior legal document, and therefore, but sometimes this is going to take arguments in court to get to the bottom of what's the correct interpretation. So that's about as simple as I can break it down. So the answer is we don't yet know what the final outcome is. But if you want to work on, I always say to people that work on the Home Office interpretation, because that's what they're saying is going to be the way that they will grant. Say, but if you don't fall within the Home Office interpretation in this particular incident, then there is, like I say, that just to be aware that the EU sees it slightly differently.
Thank you, Chris. And thank you for the follow-up question, Lara from TikTok. We are also on TikTok, not just Facebook, Zoom, and Eventbrite. So Nilmini, we have received a question from a student who is asking about student finance. The question is, are EU students in the UK who have pre-settled status still eligible for student finance if they finish university and want to do a master's degree?
Yeah, if you have pre-settled status, on the whole, provided you've got evidence of that, you should be entitled to student support. But you'd need to provide evidence of that for your course. But if you're if you're talking about home student fees, that's a different matter. When they want to move on to the master's next year, it's really to do with their current immigration status and their residence. So it doesn't matter the fact that they're going to do something different next year, if that makes sense.
It does to me.
Okay.
Thank you.
All right.
I know they are quite complex questions, and as I said, feel free to provide more generic information than specific legal advice, which you are not supposed to do.
Yes.
We also have parents who are asking questions for their kids. There is someone, I think she or he lives in Brussels. As I have pre-settled status, my son of 18 also applied for pre-settled status. This is more for Chris, I think. He's still waiting for a reply. Because of COVID and his exams, he's studying in Brussels and living between Brussels and London. My son received 2 offers from UK universities. Must he still apply for a UK student visa? What does pre-settled status mean for him? So it sounds like he, or the son or the daughter, he hasn't, it's a he, sorry. He hasn't received pre-settled status yet. So the question is, what should the parents do?
Okay, so just working from the point of view of studying at a UK university. Essentially, what a UK university has to do for EU students is determine what immigration status they have. So essentially, if someone has pre-settled status or settled status, the university can enroll them because they have the right to attend the UK university, because they have the right of residence in the UK under the sort of essentially the sort of free movement conditions that existed beforehand. If you don't have that status, then the university has to check that you have a student visa, because that's the only sort of available option to them. And obviously they have to sponsor, as we heard in the really good comprehensive presentation, the university acts as the sponsor for that person. So that's the situation. Like that's where that person who wants to attend the university needs to be by the time they start their course, with one of those two statuses. Now, obviously they've applied for pre-settled status, so they have hopefully satisfied themselves that they're eligible for that status. The parents have the status. I mean, when you're talking about living between the Brussels and the UK, my immediate things that flash up in my head, of course, is continuous residence, because we're talking about pre-settled status holders, not settled status holders. So that person, based on what we've talked about with the 6 months, needs to think about that very carefully. Sometimes with children who are connected to parents' applications, if that's what's happened here, then the child's application can take longer than the actual parent's application to be decided. That seems to be a trend within the way that the settlement scheme works, that the processing can be very quick for parents. Essentially, it depends what evidence has been put forward of residence and if it's being done off automatic national insurance checks and things like that. But we do see a trend where children who are linked to parents' applications tend to take longer to receive their decision. So it's not to say that that person's not, there's anything wrong with their application. It's just about like the way that the system processes applications. But as I say, I mean, the flag for me there is, this person's between the UK and Brussels, make sure that continuous residence is maintained. For the parent, I mean, the thing about it's most important for the parents to have that status, because they can then sponsor the child to be connected to their own status, and so that's the way the scheme sort of operates. But yeah, hopefully that covers the 2 points of getting the status. You know, if you qualify, it will come, and then that's what you use for university education. That's what you show to the university, and they you know, by university should all be very clear now that pre-settled status is the right for a European student to attend university in the UK.
Yeah, thank you, Chris. It sounds like continuous residence seems to be the key word for many issues affecting the pre-settled status holders. So we have,
Sorry, I was just going to, shall I sort of just pick up, because we're talking about continuous residence. I've just seen Antonia has put another sort of remark about continuous residence and saying,
yeah, sure, go on.
It starts, I think, well, it's a question about, it starts not from the date you entered, from the day you were granted pre-settled status, even if you weren't in the UK. Is that correct? Again, it's a little bit complicated. The status is granted on the day it's granted. So whether you're in the UK or not in the UK, the day you're granted status is undoubtedly the day that you get given the status by the Home Office. However, when you're granted the status under the scheme, it reflects the fact that you have started a continuous qualifying period in the UK. If we're talking about pre-settled status, obviously it's saying, well, we accept you started a continuous qualifying period before 31st of December, but at this point, at the point when you applied, you didn't have 5 years of residence. So it is still about the day you move to the UK. That is when your continuous residence begins. And it doesn't matter, because the scheme has only been running for everyone, like it opened to everyone in March 2019. So if someone was in the UK from January 2019, they couldn't get status at that point because they couldn't apply, but that's still the start of their continuous qualifying period. And so when you look at the time you have spent in the UK to qualify for pre-settled status, and then obviously hopefully later on for settled status, you work from the day you move to the UK. You don't work from the grants of the status, because all that is the Home Office, that's the day they decide to process your particular application, but that doesn't reflect when you move to the UK. Okay.
Thank you, Chris. Nilmini, we have a question from a student who is going to start university studies in September, and he is asking, are we going to get home fees and student finance loan for tuition if we have pre-settled status and have been in the UK for 3 years before our course started? They were working before.
The answer is probably yes. But I say probably because I think it's important to evidence all of this. If you can, then very possibly.
Thank you. Okay, there are quite a few long questions. I'm going to take one. So someone was granted unsettled status. I think this person is quite well informed about this scheme. So he was granted settled status in 2019. According to the rules, I have permitted absences of up to 6 to 12 months with a valid reason. Could you please clarify if the count starts from 2019 or 2021? I think you covered this, Chris, briefly, but he's asking when Brexit took place on the 1st of January. So there's a lot of confusions about when the date starts for the continuous residence.
Yes, I think that was I sort of picked up a sort of simplified version of that from the same person. Yeah, I mean, don't worry. I mean, Brexit, when the withdrawal of the UK happened in January 2020, that it's not a really relevant date as far as the scheme is concerned. And I think we've already sort of covered this. You start your continuous residence when you move to the UK. That's when your 6 months sort of allowance lasts from or starts. The day you get granted pre-settled status is not relevant to that calculation because you want your 5 years starts from when you move to the UK. The only thing I can add to that, just to sort of add, as usual, an extra layer of complication is that if you moved to the UK in 2019 and then you were granted, let's say, pre-settled status in July 2019, if for some reason you then left the UK for 13 months until August 2020 and then you came back, what you've done according to the rules is you've broken your continuous residence because you're outside for more than 12 months. But you've also come back before the 31st of December 2020, which is the cutoff date to begin residence. So in that situation, you have broken your continuous residence connected to your initial grant of pre-settled status, but you've started a new continuous qualifying period by coming back before the 31st of December 2020. And in that situation, what the scheme will allow you to do is to apply for some more pre-settled status to give you enough time to build up your 5 years starting from when you came back, in my example, in August 2020. So you haven't lost everything because you broke your continuous residence, because you came back before the end of the transition period. If you did the same thing today, if you left in July 2020 and you came back in August 2021, the scheme doesn't allow you to do that because you can't start a new qualifying period after the 31st of December 2020. So as usual, we see some, the rules, which are ideally straightforward, become more complicated by what's happened to people. But that's how it would work for someone. If someone has broken their continuous qualifying residence, they need to look at whether they were back in the UK by 31st of December 2020.
Excellent, thank you. There is another one. I think this is also for you, Chris. It's someone who is asking about access to benefits as a pre-settled status holder. So the question is, my partner came to the UK in March 2020 and she's working. Due to lockdown, she couldn't get a national insurance number, but she does have pre-settled status. When she went to the NHS, they were asking that they were telling her that she will be charged for the services because she is considered a visitor. So how can she demonstrate to the NHS that she is not a visitor, and why she is not getting the national insurance number?
Right. Okay. So the fact that someone has pre-settled status tells that should tell everyone that they're not a visitor, because you're not given pre-settled status if you're visiting the UK. So that's the thing. So this person's right. If you have pre-settled status and you still live in the UK, then you have the right to free NHS treatment. You should not be charged. The NHS has to assess whether someone is considered to be ordinarily resident in the UK. We've already heard a bit about ordinary residence and what does that mean. But basically, if someone has pre-settled status and they live in the UK, they haven't left for a long period of time, they are ordinarily resident in the UK, and the NHS should not be trying to charge anyone. That is a situation where someone in the NHS charging team does not understand what the rights that EU citizens have under the settlement scheme, under the withdrawal agreement. So it's not that the person doesn't have the right, it's that the interpretation of their right by another government department is not being accurate. So it's very stressful and very difficult and shouldn't happen. But ultimately, this person will not be charged for their treatment on the basis that they have pre-settled status and they live here. Okay, so the national insurance number is a slightly different issue, because national insurance number is not required to receive NHS treatment. As I said, that the conditions of that are what I just explained. The problem with national insurance numbers came about because of COVID. The way that national insurance numbers were issued to EU citizens was on a face-to-face interview, because the Department of Work and Pensions office has to confirm someone's identity. So it was a big problem. Essentially, NI numbers were suspended for EU citizens issuing them for the whole of last year. There is now a system in place where if you have been through the settlement scheme, either pre-settled or settled status, you should be able to obtain a national insurance number without having to attend a face-to-face interview. So again, hopefully this person will be able to resolve that situation. But as I say, in terms of the NHS, national insurance number and NHS is not, you don't need an NI number to access NHS treatment. That's done on the basis of their status and being able to prove that they live here, basically.
Thank you. I think we have 2 minutes left. So just one very quick question from someone who is on Zoom and put a question in the Q&A. I will just read out part of it. This person was away for over 13 months. He has pre-settled status, and he was abroad doing Erasmus studies, holiday, and difficulty returning to the UK because of COVID restrictions, travel restrictions. So I think the question is, does this qualify because he was breaking the continuous residence?
Yeah, so did you say that this was a pre-settled status holder or someone?
Yes, yes.
And it was 3 months, 13 months, you said? Is that
13 months, more than a year.
Okay, yeah. So obviously, when I was previously explaining it, I was talking about once you break continuous residence according to the rules of the settlement scheme, did you then come back before 31st of December 2020 to begin a new qualifying period, or did you not? I'm going to assume from the tone of the question that the person hasn't come back before 31st of December, and therefore their concern is obviously that they've now broken their continuous qualifying period, which means under the rules of the scheme that they cannot convert to settled status in the future. This is a really, really difficult, although someone's just popped up and said, I came back. Okay, if you came back before 31st of December 2020, after being away for 13 months, as I said before, then you're covered because you started a new continuous qualifying period before the end of the transition period. So you can get more pre-settled status, you can build up the 5 years on the assumption that you don't break continuous qualifying residence again. For someone in the same situation, if they came back after 13 months, after the 31st of December, the rules say that that person would not be eligible for settled status. I think one thing it's really important to make clear at this point is that this is another area where there may be some disagreement in how the rules operate, because the rules under Appendix FM are under Appendix EU are absolute rules. They basically say if you are away for 6 months and 1 day, that's you breaking your continuous residence. If you're away or if you have your important reason and you come back after 12 months and 1 day, you've broken your continuous residence, and that's the end of the discussion. We will not consider anything else to do with why that happened because you've gone over the allowance. There is a suggestion that that is not necessarily how the withdrawal agreement would approach that situation. The withdrawal agreement would appear to be potentially more flexible in considering whether what going over by 1 day is actually a situation where someone should lose all their rights to get settled status in the future. So that's just something to bear in mind for people. It's very difficult to talk about that again because it's about an interpretation, and we've got all these interpretation issues that may at some point have to be dealt with in sort of case law and things like that. So I can't say what the definite outcome is, but it seems to me that there's a possibility that the absolute wording of the rules of the settlement scheme may not quite comply with what's actually expected or under the withdrawal agreement in terms of people who literally, like, if you miss out by 1 day, what you lose your right to get settled status in the future, that might not be quite right. But that is how the rules are written today. Okay.
Thank you, Chris. I think we have to wrap up. We are already running by 1 minute over the time that we had. Thank you so much, Nilmini and Chris. This has been very, very useful, and this session was recorded, and I think people can watch later on Facebook, and also it will be on YouTube. So if you missed it, please share it and please watch it. It was quite a comprehensive and a very complicated issue. I think as a wrap up, I would just say that if you are an EU student, please apply for settled status. The deadline is 30th of June this year, and also tell your friends at campus or on Facebook, anywhere, that they should apply if they are EU students to the scheme until the end of June. Antonia, did you want to say the farewell?
Sure. Thank you so much. This was so informative and really, really interesting. I learned a lot, and I'm sure a lot of people and our viewers learned a lot as well. Like I said, this is being recorded. It's going to be up on our Facebook Live, so you can watch it anytime. It's also going to be on YouTube, and we will be sharing it out for all those who are registered to the webinar as well. So plenty of time to watch it. And thank you so much to our fantastic speakers. You know, they've taken time out of their schedules to do this for us and volunteered to try and help get the word out and to raise awareness. The last thing I'll say is, if you are an EU citizen and you're watching this, EU citizens can register to vote and can vote in local elections. The deadline is tomorrow, so make sure that you are registered to vote and you're out voting in local elections on the 6th of May. And that's it for me. So thank you so much for everyone watching, and thank you to our panelists for coming today.
Thank you for inviting us.
Thank you.